Our next speaker is going to be talking about the Second Amendment protection of non-firearms. The attorney from the law office of Alen Beck and the 2024 Bill of Rights Award winner, Alen Beck.
So today I'm going to be talking about the protection of weapons and other items that are not firearms. When we think of the Second Amendment, we think of rifles, handguns, etc. But both historically and as our jurisprudence is developed, the Second Amendment applies to any number of weapons that you can use to defend yourself. The first modern case to discuss the Second Amendment was United States v. Miller. And in Miller, the court was evaluating the constitutional protection of a short-barrel shotgun. In that case, the defendant, it was a criminal case, didn't submit a briefing or show up to court when the case finally made it up to the U.S. Supreme Court. So what the court said is here, because nothing's presented, we can't rule on the Second Amendment protection, but we're going to establish a test, and that's here because it's not within the judicial notice that a short-barrel shotgun has a reasonable relationship to the preservation or the efficiency of a well-regulated militia. Now, that was in 1939. Heller comes along and it clarifies what the Supreme Court said in Miller and established that among the militia functions is the right to personal self-defense. That's what we think of, when you're defending yourselves against a break-in or robbery. And it did an excellent historical analysis of what the term arm meant around the time of the founding, at the ratification of the Second Amendment. And it used a number of dictionaries from that time to make that, define that term. And it cited to, notably, Timothy Cunningham's 1771 dictionary, and defined arms as anything that a man wears for his defense, or takes into his hands, uses in wrath to strike another. And what we know from that is that the term arm applies to anything that you can bear upon your person to defend yourself, or anything you can wear upon your person to protect yourself from attack, so also armor. The term arm refers to both weapons that you can use and armor that you can carry upon your person. So unfortunately from that definition, things like, say, cannons might be out of the question, but based upon Heller's definition of an arm, there's all sorts of weapons that are protected. Now, I'll go into my litigation really quickly. I got the idea, probably back around 2011, which was my first Second Amendment case. We started thinking about the idea of what weapons are protected other than firearms. And, I worked on this for a couple of years. Eugene Volokh was a professor at UCLA. Had done a good deal of research, and after we did one case on the issue, and the court avoided the constitutionality, and we took another shot after the Saitano opinion. In 2016, the Supreme Court ruled on a litigant criminal defense case of a woman who was in a parking lot, and the police found her with a stun gun. She went up to the court, and initially the trial court upheld the conviction. It ultimately went up to the U.S. Supreme Court, and the record was pretty established. This woman had kept a stun gun because she had an abusive boyfriend, and she needed this. She was homeless, and she needed this to protect herself. And the Supreme Court said, this is, the lower courts have gotten this wrong. We're not going to expressly find this stun gun is protected, but here's the test. We're going to reiterate the test. You have to figure out, is this a bearable weapon that you can use in a self-defense situation? And after that, myself, my co-counsel in a number of these cases, Stephen Stambolia, who we filed a number of taser cases across the country, and we were able to overturn the bans in Rhode Island, New York, New Jersey, and Hawaii, and about half a dozen cities across the country. And a friend of mine, George Lyon, took out the District of Columbia statute. So after that, we decided that we were going to file some more lawsuits, because Heller very clearly uses a knife as an example of an arm. So we thought the next great case is going to be on the issue of knives. And at that time, we were already seeing some of the great work Doug Ritter had done on the legislative side, trying to get rid of the bans. But the truth is, there's a few really die-hard gun control anti-Second Amendment states out there. We already know we're in one right now. And, I work mostly in Hawaii, and we knew that the odds of the legislature doing anything in a couple of those states just going to be slim to none. So we filed a lawsuit on the constitutionality of a butterfly knife. Now, a lot of you may be wondering, what is a butterfly knife? A butterfly knife is a traditional Filipino martial arts knife that has two handles. At the time, there wasn't spring technology, so the Filipinos decided to have a second knife to make the knife safer to own. Because of that, it's a crime. Simply because a knife has a second handle, you can go to jail for having it. And in Hawaii, that's a quarter of the population has some type of Filipino ancestry. So this was a law that was put into place because they didn't like Filipino workers coming over and be able to have their traditional weapons. Because, due to the history of Hawaii, a lot of the plantation owners need to bring in workers. And they didn't like the idea of the plantation workers having access to weapons. They banned both Filipino weapons and a lot of the native Hawaiian weapons. And, that always didn't sit right with me. So we brought a lawsuit on that. Actually, we won from a 3-judge panel of the Ninth Circuit. The state of Hawaii was concerned that we might, this case would set bad precedent for the AR-15 bans and a variety of other litigations happening right now. So not only do they get rid of their butterfly knife ban in an effort to moot the case, they've also gotten rid of all their weapons bans that don't deal with firearms. So right now, one of my clients, I should have gotten a slideshow, because my clients walks around every night with a halberd as a 16th century battle axe. And he's been walking around Waikiki with that thing. Come after me afterwards. I'll show you some photos. We're having a lot of fun with this. And, I actually flew, I live in San Diego, so I fly out there quite a bit. And, we had a rally. We brought katanas. We brought Scottish claymores, halberds, you name it. And, man, a lot of tourists were wondering, what the heck is happening in Hawaii? We did not see this on the brochure. So, that's what I've been doing. We've got ourselves, I've got litigation here in California, and on the issue of batons. A lot of you may know Judge Benitez, who has been known by many in the Second Amendment community as Saint Benitez. And, in California, it is a crime to have a baseball bat in your back seat of your car. It is actually, you can be charged with a felony over that, because they have a billy club ban, which originally meant to, it's billy club, police have them, ASP. Well, that law is actually being interpreted to refer to any club whatsoever. I have a friend, he's a criminal defense attorney up in the Bay Area. Guy comes in, police show up for a noise violation, and to make a long story short, the guy has the piñata stick. He's a Hispanic fellow. There's, they're having a party. They have a they have a pinata. Guy, through a confluence of events, guy got charged with possession of a billy club, even though he wasn't engaged in any sort of hostile activity, because he was drunk trying to hit a pinata, right? And, my friend's a criminal defense attorney, he was just like, well, you need the felony, or you can, we can try and fight the felony, or I can plead you out to a pretty light sentence. Well, the point is, the guy was turned into a criminal over a pinata stick. That's how crazy this law is in California. And thankfully, Judge Benitez saw it our way, and we prevailed on that. That case up on appeal November 6th. I'm going to be arguing in front of the Ninth Circuit. And I want to go through a few other things while I still have time. Right now, let me tell you about some of the current litigation that's happening. I've talked to you about some of mine. There is a case, like I said, the term arm refers to both weapons that you can attack a person or defend yourself with a person, engage offensively, and what you can put on your body to defend yourself from attack, i.e. body armor. So, to my knowledge, the first modern body armor case was filed against New York's ban on body armor early this year, and that's very early in the stages of the litigation. So I'm very hopeful that the judge will simply read Heller and read the text, but that doesn't always happen. So I'm looking forward to see what happens in that case. And my good friends over at Knife Rights, Doug, can you raise your hand if you're still here? Oh, there you are. He is, Doug, like I said earlier, he's done a fantastic job. He filed an amicus brief in my butterfly knife, and he's overturned, I want to say 18 states, but I could be wrong, the bans on switchblades through the legislature. And recently, after Brune, he decided he was going to take a part in litigation. So he's filed, to my knowledge, 2 cases against the remaining state laws, and then one lawsuit against the federal ban that deals with commerce in switchblades. And interestingly enough, for whatever reason, if you're a Native American living on a reservation, you cannot own a switchblade on Native American land, or if you live in Puerto Rico, one of the other territories. So I don't know. Maybe there's an equal protection claim there as well. But so that's what's going on right now in terms of current litigation. There's a few other things out there that this has been my little baby. I'm 12 years ago, no one, a lot of people didn't even think this applied to non-firearm weapons, and I've been thinking that if not me, then maybe somebody else will consider looking at New York's ban on pepper spray. In New York, all pepper spray has to be watered down compared to the rest of the country. I want to say it's 3.2 cannabinoids, which probably doesn't make sense to anyone. But anyway, so everyone in the pepper spray industry has to make a special watered down blend of pepper spray just to sell in New York. Now, that just doesn't make sense. Beyond anything else, something I've been trying to stress with these non-firearm lawsuits is this makes bad public policy. We all know, because of Heller, you have a right to own a handgun, defend yourself, and use lethal force against an assailant. So why do we have restrictions on pepper spray, on tasers, on batons, on certain cultural knives? It's just bad public policy that was put in place before the courts recognized the Second Amendment, and quite frankly, because people have inherent fears of things they don't understand. They saw some bad movies in the 1950s that, Betty and the Jets, right? And they thought, heck, let's ban it because we're the government and we can, and we don't like how this looks. And that doesn't make sense. I'm hoping that we as Bruin continues to be litigated, and my friends in the legislature continue to do their work lobbying, that we can get rid of a lot of these laws just simply don't make any sense. Because to conclude, Heller and Bruin make it very clear that all bearable arms are protected, not just firearms. So with that, that's my presentation. Now, Doug Ritter at Knife Rights has a special treat for all of us, and he's going to come up here and let everyone know a little bit more about Knife Rights and his little treat. So thank you very much for your time. My name is Alen Beck, Law Office Alen Beck.
All right, thank you, Alan.